Appeals Division 1 is now in session.
Please be seated. This is time set for oral argument in our case number Civil 14-0249, A minor versus City of Flagstaff. Each side has been allocated 20 minutes for oral argument. The appellant, you have a chance for rebuttal, but the 20 minutes includes your rebuttal time, so you have to reserve your own time for rebuttal. There's a clock in the podium, and the time that shows remaining includes your rebuttal time. To give you some advice, we've read the briefs, we've looked at pertinent portions of the record, we've looked at the relevant cases, so we're familiar with most of the facts and the arguments, and we've conferenced the matter and discussed it. So when you approach the podium, you can guide yourself accordingly. You don't need to spend a lot of time on the facts unless we have questions. When you approach the podium, please clearly identify your name and who you represent, so you know this matter is being both digitally recorded and visually recorded. So in about 2 weeks, you can actually see the argument on YouTube. With that, counsel for appellant.
Good morning, and may it please the court. My name is David Lunn. I'm with DKL Law Firm.
Mr. 1 second. Could you start the clock? Thank you. Go ahead.
Thank you. Like I said, my name is David Lunn. I'm with DKL Law Firm. We represent A Minor Contracting, Inc. A Minor Contracting is a general contractor, and for approximately the last 40 years, has been in the business of doing public works projects, and that's finding infrastructure, mainly groundwork with roads, sewer lines, power lines, things of that nature. And today, as the court knows, we're here on a notice of claim issue, and the issue is whether or not the trial court erred when it found as a matter of law that A Minor Contracting's notice of claim did not comply with the applicable notice of claim statute. And we submit that the trial court did err as a matter of law because we believe that there was a sum certain that was offered, and if accepted, it would have been binding upon A Minor Contracting. There were facts sufficient to support the claim amount, and what the theories of liability were against the city, and that the claim was timely filed.
Counsel, let me have a question about the sum certain. The notice of claim talks about, that's January 21st, 2008 notice of claim. Right?
That's correct, Your Honor.
And it refers to, on page 2, page 2, $1.825 million and change, plus additional accrued interest. And then the best I can determine is the only reference to only other reference to $1.825 million in the other documents is in the notice of mechanics and materialman's lien, which says $1.825 million is the amount of the claim, plus change, 18% interest on page 2 of it. But it's a little unclear. I have 2 questions. One is, was the mechanics lien attached to the notice of claim?
Yes.
It was. Okay. Second question I have is, given that, how from the face of the document, face of the notice of claim and the attachment, could the city have determined when the interest started to accrue?
Well, that's a very good question, Your Honor. And then when you look at under applicable laws, when does interest accrue on a liquidated claim? It accrues when that amount's due and owing. And in the mechanics lien statute and in the construction arena, there's 2 times where the claim accrue really is. 1, when the contract is breached, or 2, upon substantial completion. And contract being breached being no payment, substantial completion with this contract.
What's the statutory site for substantial completion?
It's dealt with under the MAG specifications.
Well, now, excuse me, MAG specifications are not part of the statute, as I recall. So, substantial completion is a term of art. It's also mentioned in the contract here, correct?
That's correct, Your Honor. In this case, completion was defined by the contract, with the contractor completing the scope of work that was under the contract. And so the date of completion of the contract is when that work was completed.
But the contract doesn't say that. The contract, neither the contract nor the addendum, as I read them, specified a precise date where the final payment was due. It talks about what is substantial completion. It talks about retention, the 5%, and then the 1%, and so forth and so on. But I didn't see anything that specifically said that 30 days post or 10 days post substantial completion or something of that ilk, all amounts are due.
I would agree with, there may not be specifically that language. I think there was language about payment within the contract, but I also am very confident that when you have a contractor doing work on a project, there's the Prompt Pay Act, which commands when payment is due if not otherwise specified in a contract.
But that's not in any of the notice of claim.
I don't think that's
the Prompt
necessary.
Pay Act and the MAG specifications and all these additional things that, and I want to get back to Judge Kessler's question, but all these things you're referring to, they're not in the notice of claim. So someone has to think, okay, I need to look at this statute or that statute or this notice or these specs to figure it out.
Well, I think if you look at the notice of claim and with the documents attached as a whole, Your Honor, that you'll see that the notice of claim, could there have been more specificity in the notice of claim? Indeed, there always could be. However, I believe that the documents that supporting the claim substantiate that claim in that the amount is set forth of what is owed. We know the date of when it's owed. The date of completion is what's set forth in the lien, mechanics lien, and that's the triggering effect of when you have a liquidated sum.
How can, and maybe you can help me on this, but, so I look at the mechanics lien, and it says effective date as reflected in the recorder's stamp above. Then it has completion date as defined by 33993 occurred on August 22nd.
Correct.
And the lien is dated the 30th day of August 2007.
Correct.
So if I'm the city, how do I know? So I'm trying to piece this through from the city's standpoint. They get the notice of claim. They see $1.825 million in the notice of claim.
Correct.
They look through the documents. There's only one document that refers to $1.825 million. That's the mechanics lien. It says the interest rate. How do I know by looking at the face of this that interest is going to start to accrue, that you're claiming that interest is going to start to accrue as of a certain date?
Well, Your Honor, it goes back to, that's a good question. It goes back to what is the law on liquidated damages and when does interest accrue? It's when the amount is owed. And so by looking at the mechanics lien, the date of completion is the date the amount's owed because the work has now been done. And so payment is due on that amount. And so when you show this, and when you look at a construction project, throughout the course of the construction project, you don't see contractors filing interim notices of claims or interim lawsuits because the law doesn't encourage that. You wait till the project's over, till the contract is terminated before you then pursue the claims, because otherwise you'd have piecemeal litigation and you could have inconsistent verdicts, and that's contrary to the principles of having the efficient judicial system. And so the way in construction cases that it works is that it's either the triggering point for the accrual is going to be the breach of the contract or substantial completion when the payment is due and not paid.
Well, if that's the case, then doesn't that cause a problem here as well? Because then, if it could be either when the contract is breached or at the time of substantial completion, what is the city then to intuit? Which is it?
Well, thank you, Your Honor, and I think that is a good question. I think that really, when you look at it, I mean, cities aren't aren't foreigners as far as entering contracts to get improvements done. And cities know that when substantial completion is done, that the remaining money is due on the contract.
That's substantial completion, but if it could also run from the date, interest can accrue from the date of the breach, again, the whole purpose of the notice of claim is so municipality or governmental entity receives the notice, they should be able to write a check right then.
I agree.
How could they do that if, in fact, it could be date of the breach or substantial completion?
Because the date that is set forth in the document and in the documents to support it show that the lien is effective on that date, at the date of substantial completion. And that's the date that would be known to the public entity is when the claim, that's when the claim is going to accrue. That's when we have an amount certain.
Let me ask you about that. You talked about the standard and what goes on in the construction industry, and I do understand and that. And that makes sense, everything that you said, when you have a traditional construction contract between an owner and a contractor. But here, the city, A minor's claim against the city was, as I understand it, basically unjust enrichment. That it accepted or received the improvements which it accepted and thus needs to pay for them. Does the nature of the claim then affect the interest issue? Because, for example, let's say that and I don't know, maybe you can help me on the record, the notice of claim reflects completion was on August 22. But if the city accepted before or after August 22, wouldn't the claim then run for there, so wouldn't the interest accrue from there? So the fact that the lien as against those subject to those who would be subject to the lien specified a date of August 22 for completion, does that necessarily then apply in this context when the claim is unjust enrichment against the city?
It would, Your Honor. And the reason I would say that is because just because you accept something, that doesn't mean you're necessarily responsible or liable for paying for that at that time. At the time, there's a contract with the developer to pay for those goods. And it wasn't until the substantial completion and the lien was filed when the contractor knew it wasn't getting paid. At that point, it's looking to the city to be, and the unjust enrichment claim to be paid for that amount, the sum certain as of that date. And that is why the date is specific as to when the claim accrues, because that is the date that now we know when the lien is filed. It identifies when the substantial completion was, and then it identifies by the mere fact of filing a lien that you have not been paid. And that would be the triggering the liability for the unjust enrichment claim against the city.
What do we make then of the promissory note?
The promissory note was a note between the developer and between the contractor. So the city's obviously not a party to the note, it wouldn't be bound by the note.
But doesn't that confuse the issue?
I think that the issue at face value...
At least as to interest.
I agree, and I'd like to address that, Your Honor. Because that is clearly the focus point of the notice of claim of the opposition and saying whether the notice of claim was invalid. And I think that, you know, as the panel, the court looking at this de novo, you look at, under the applicable law of Arizona, what is the interest rate that would apply to a liquidated sum? And there's interest rates that are set forth with the notice of claim. If you're going against the contractor, if you're going against the owner, you're going to have the Prompt Pay Act, and that would be the interest rate that would apply to the Prompt Pay Act. If you look at the interest on the promissory note is between the owner and between the contractor. So that interest would apply to that. The city is not bound to that. So when you're looking at an unjust enrichment claim, you look towards what's the codified law in Arizona, what's controlling in that regard. And at ARS 44-1201, if you don't have a contract that specifies otherwise, if you have a liquidated sum, the interest rate is capped at 10%. So under the law, there would be no way that A minor contracting could seek an unjust enrichment claim against the city and receive more than 10% for that claim. And so I would suggest that if the purpose to notice the claim is to investigate the claim and assess potential liability to determine whether or not you can settle the claim. And unlike the cases you look at in Deer Valley where there's quantifying language saying we have economic damages at least this much and we have pain and suffering as at least this much, that's unquantifiable. Here, with an interest rate, we have a finite sum that is quantifiable based upon the permissible interest rate, which would be 10% for the default rate for on a liquidated prejudgment interest. I'm sorry, I misspoke. On a prejudgment interest claim on a liquidated sum, pursuant to Arizona law, that rate is capped at 10%.
But that's the promissory note.
Your Honor, the promissory note, I think the rate was 22%.
It was
18,
12%.
12%.
It's 12%.
I think it's 12% on the promissory note. But then the promissory, so here's the problem when Judge Norris was asking the question. The problem why the promissory note to me makes it confusing is that the promissory note said that you pay by August 31st, otherwise interest will start to accrue at 12%, I think it was 12%, on September 1st. And I'm assuming the promissory note was somehow related to not being paid. In other words, you're going to pay me, you're going to pay off this promissory note, so I know that I get paid at least something that I'm owed, A minor, something that I'm owed. So when you look at when you file a notice of claim and you attach the promissory note, that can be even more confusing, because then you're starting about a different date. You're talking about, well, okay, the completion date. Let's get back to the only document that refers to $1.82 million is the mechanics lien.
Agreed.
And it says 18%. But then you're saying, well, it's the completion date, which is August 22nd. That's when it accrues, although that's not what the lien says, and that's not what the notice of claim says. But then you're talking about, well, and we haven't been paid. Well, you haven't been paid as of August 31st. So that's another factor that creates some confusion. Is it August 22nd? Is it August 31st? Is it, which is it?
I agree, and I understand how, if you're looking at this packet without a general understanding of how the law works, and that's why governmental entities take a look and they have counsel to review, they would understand, and I think it would be disingenuous for them to imply otherwise, that an interest rate in a promissory note between a non-party is not binding on the city. I think it would be disingenuous for them to argue otherwise. I think it would be disingenuous for them to believe that the notice of claims, the Prompt Pay Act would apply to them because they weren't the contracting party. And so,
why attach the note then?
Because the note, what you're charged with doing when you file your notice of claim is to support the allegations in the claim. And so supporting the allegations doesn't mean that is, what we're doing when you support the documents, we supplied all the invoices. We supplied the mechanics lien. You're providing all this information to show that this work was done and that it has been paid for. And so it's a supporting documentation.
Is it asking too much on a $1.8 million claim to put in your notice of claim the amount that's owed and the principal rate and the date it accrues? Is that too much to do?
Is it too much to do? I don't think it is too much to do, Your Honor. I think that you could do that as well. I think that the fact that you're putting in an interest rate that is a known quantifiable interest rate based upon the operation of law, I think that would suffice for the purposes of notice of claim.
Is the intent of the statute to do what you're arguing here, to have the city run around and look at statutes and sift through these documents and try to sort out what exactly the interest rate is? I mean, is that really the intent of it?
I'm sorry for interrupting.
That's all right.
I think the intent of the statute, I'm sure the intent of the statute, is to promote settlements, to give the city an opportunity to analyze and determine the potential liability under settlement. And I think part and parcel of that process is looking at what is our potential liability, and based upon that liability, can we accept this claim? And I think that the critical point of a notice of claim statute is that if the city or municipality or county says, we accept that amount, we're going to pay that amount, is that an amount certain? And I suggest to this court that this is an amount certain because there's a quantifiable, finite, identifiable amount that if the city of Flagstaff said we accept that matter, we would have been bound to take that amount plus 10% interest, the statutory interest, as a matter of law. That would have been enforceable against us, and I think that's the entire purpose of the notice of claim statute, and that was complied with, Your Honor.
It's now it's not 10%?
Pardon me?
It's 18%.
18% is under the Prompt Pay Act. Under the Prompt Pay Act, if you're the contracting party.
Your notice of mechanics lien says 18%.
And that is against the property owner. That is correct. But and that's looking at a contractual relationship. We're looking here with the claim. The claim is set forth in the notice of claim is an unjust enrichment claim, so it's a different set of factors. It's not a breach of contract claim.
Making it even more confusing.
And I was afraid that was going to happen.
For me, I mean, I'm just looking at it from the city's standpoint. They don't know.
But they should, because if you look at what the factual basis is and the theory upon which the recovery
Right.
is being sought, under that theory, the city would know that this is a liquidated sum and that the amount of the interest would be 10% on that claim.
Except that the notice of claim doesn't say the amount of interest, and the only document attached to the notice of claim that refers to 1.8 million says 18%.
I agree.
That's pretty clear. That's pretty clear if we know when it accrued.
I agree there's some confusion created by the documents, but I also sincerely believe that when part of the analysis is looking at is, well, who would be liable for this? And it wouldn't be the city. And what would the city be liable for? And I also believe that the notice of claim statute isn't meant to be a draconian measure where valid claims are kicked out because the city's not taking positions that aren't reasonable, saying that this would be the interest rate applied on the promissory note when it wouldn't be. There's no.
So is it your argument that the interest rate was 10% or 18%?
For an unjust enrichment claim on a liquidated sum by operation of law, the maximum interest rate permissible would be 10%.
Forgive me. I feel a little confused here. I thought the position A minor had taken in the trial court and on appeal was that the interest accrued on the 1.8 million at 18%. Are you saying that, and forgive me if I misunderstood, I apologize for that. Are you saying that really because this is an unjust enrichment claim, it was 10% per annum?
Yes, Your Honor. I think there may have been confusion in the underlying documents, in that I think the point that was being made is that if you quantify it at 18%, 12%, 10%, it's a finite quantifiable amount. And I think if you're looking at, if there really is a question, a legitimate question, I think under the Backus versus Arizona case, that it's easy for the city to clarify that. I'm not saying it's a duty for them to do, but I don't think under the current circumstances, given the operation of law and how it works, that there should be a question about it.
I will add to you that in the response to the motion to dismiss, you argued, your A minor argued it was a 12% interest rate on page 10. The interest can easily be calculated pursuant to the terms of the above referenced promissory note, which by its terms is calculated as simple interest at the rate of 12% from August 22, 2007.
Well, I'm not going to argue with what the.
You can see, I mean, that's what, I'm just saying what it was, so it did seem to, it seems like it's a moving target once you get to the litigation.
I fully understand, and I also hope that you can appreciate that when you really take it down to looking at the operational law of what you'd be entitled to interest, then maximum you'd be entitled to would be the 10% under the law. Okay. And that's really what to look at.
Okay. Will you add 2 minutes to both sides? And we asked you a lot of questions, so I didn't want you to. Or you should have 2 more minutes for rebuttal.
I appreciate that, Honor, and I will wait for rebuttal.
Thank you.
Good morning. My name is Cameron Artigue for the City of Flagstaff. Judge Gould, I would start with your question, which is no, it is not too much to ask. The Supreme Court was correct when it said in Deer Valley that this is not a hard statute to comply with. The claimant is the master of the offer, and the claimant can say, we'll settle for $1 million, we'll settle for $1.5 million. You know, all you have to do is make it a specific number, and that's crystal clear in the law. The colloquy over the past 20 minutes illustrates.
Are you okay?
Sorry.
I'm sorry.
Sorry, I
illustrates
apologize.
the
I was trying
problem
to get
here.
something related to your argument.
Okay. How would this court reverse the trial court and conclude that indeed the notice of claim specified a precise, exact, definite amount when we still don't know what that amount is? It's not in the opening brief. It's not in the reply brief. You haven't heard it here this morning in oral argument. You need, if you're going to say, oh, there's a dollar amount here, there's a precise, exact, definite dollar amount, what is it? And as you've demonstrated, the notice of claim here says plus additional accrued interest. It then attaches 70 pages of documents that could not possibly be more confusing. If you tried to make this complicated and unclear, you could not do a better job. Okay, let's attach a mechanic's lien. This isn't the city's property. This is private property. Okay, so it's not even, the lien isn't even attaching to anything owned by the city. But let's attach a mechanic's lien that has an 18% interest rate. Okay, well, presumably that's relevant. Let's also attach the original contract between Premier and A minor. That's got an 18% interest rate. Then let's attach a promissory note that has a 12% interest rate. And then we won't mention any of these interest rates in our actual notice of claim letter. The notice of claim letter doesn't say mechanic, it doesn't say lien, it doesn't say August. It says unjust enrichment, and the only date that is mentioned in the notice of claim letter is June 29th, 2007, and that date is mentioned 3 times. So there must be some significance to that date. Now, in addition to these factual confusion, you see this kind of bobbing and weaving over what the plaintiff's argument is. In the trial court, they said, oh, interest is 12%. Okay, interest is 12%. I'm not sure where you can find that, but at least we know what the plaintiff's argument is. On appeal, in the opening brief, page 17 in this court, they say, well, it could be many things. It could be 10%. Interest, you could read this as 10% interest. Well, okay. And I commented on that in my brief. And in the reply brief, the plaintiff says, well, or it could be 18. It could be 18 on page 5 of the reply brief. Or on page 4 of the reply brief, it could be 0. Okay. And this morning, you heard, well, it's really 10. Now, this is just one variable. The other variable is when do you start the clock? And that's another complete mystery. Now, this is not what the statute requires. Deer Valley didn't say, gosh, let's have panels of judges try and take a guess as to what the amount was years after the fact. It's easy. We'll settle for $1 million. That's like filing your notice of appeal within 30 days. It's something that any licensed Arizona attorney should be capable of doing. Put a number in your notice of claim. Compliance is not difficult.
I mean, if there were an attached chart or a formula that said, without specifically a number, I mean, for instance, if the notice of claim said, you owe us a 1.8, we'll settle for $1.825 million plus interest, see attachment A. And attachment A said the interest shall be at 18% from a date certain. It specifies a date. That would comply with the statute, right?
I think that does, Your Honor.
Okay.
Yes, I think that if you put the number, in an attachment that's clear and unambiguous, that's fine. If you put the number in Spanish, I think that's fine. I've sort of run through this question myself.
It's a formulaic way.
Yeah.
A formulaic way to specify a sum certain.
Yeah, and I guess what I would go back to, and the case law hasn't done this, but I go back to is it a liquidated amount for purposes of prejudgment interest cases, without reliance on opinion or discretion. If you can only get one right answer, unless you're making an arithmetic error, then it's good. If there's one right answer.
I'll tell you that, to me, looking at it from the city's standpoint, regardless of what was argued, I mean, I understand your argument, what was argued, and it seems to be a moving target afterwards. But from the city's standpoint, the statute says we need a sum certain. And like it's an offer and an acceptance. That if the city said, I accept, I will pay you that amount, everybody's bound. And the only document that refers to, the only two documents that refer to $1.825 million are the notice of claim and the notice of mechanics lien. And the notice of mechanics lien also has an interest rate. So it's getting closer. The problem, it seems to me, is, so the city could have said, okay, they tell us we owe $1.825 million at 18% interest. The problem from my standpoint is 18% interest from when?
Correct.
And because there really isn't anything, and that's why, and I apologize for going over there and picking up the statute book and making that noise, but I wanted to double check because the notice of lien, mechanics lien, refers to 33,933 and it stays, but 33,993 doesn't refer to any kind of when interest will start to run.
It does not, Your Honor. And the mechanics lien, the whole statute there implies that you're recording and enforcing a lien against the owner's property, which this is not. So we have in the reply brief, they say, well, it's August 22nd, 2007. That is, yeah, you can dig that date. That's in the 70 pages of attachments.
Well, that's also on mechanics lien.
Right. But so are 50 other dates. I mean, it's not a matter of, on appeal, I have a full deck of cards, pick any card and we'll know what card it is at that point. You've got to be precise and definite on the front end. That's what the statute requires. That's why compliance is not difficult. It's not a matter of backing and filling. And as I said, when the appellant in its own papers and its own arguments says could be 0, could be 10, could be 12, could be 18, could be this day, could be that day, let me move on to I think the sort of a couple other fallback arguments that the appellant has hinted at. Something you might say is, well, this is interest isn't very important. It's de minimis. The interest. Gosh, it seems kind of trivial. This is 6 figures of interest. Okay, this is. If the plaintiff had said we'll settle for $1.8 million plus the price of a new Mercedes S-Class.
I'll take that deal.
Yeah, well, yeah, and suddenly it's not so trivial. And you wouldn't say, well, just that Mercedes is kind of a de minimis free gift with purchase kind of thing. We'll just disregard. It's liquidated. Never mind the Mercedes part. No. What the plaintiff's offer basically said is we'll settle for $1.825 million plus an additional number that ranges from $30,000 to $200,000, which is the equivalent to saying we'll settle for $1.85 million to $1.95 million, which ain't a definite, certain, precise amount. So it's not de minimis. What is implicit, what I get out of plaintiff's briefs, with all the sort of, well, it could be this, it could be that, it could be this other thing, is we're flexible. The door was open to settlement. You could have just called. We were all ears. We were reasonable people. That's a wonderful attitude if you're trying to have a settlement conference. The Supreme Court said in Deer Valley, this ain't about that. It doesn't matter that you were reasonable or got the settlement discussions going. You must name a number.
But why shouldn't, in Bacchus, the
Yes.
Supreme Court said when you're talking about the facts underlying the amount, if it's a little unclear, the public entity can call the attorney's counsel and say, we need more information. Why shouldn't that apply to, we need more information to apply to some certain amount?
Well, there are 2 parts to the statute. There is a different Supreme Court case on each part, and those Supreme Court cases, one is generous and the other is not. And I think that's because one is more judicially administrable than the other. The facts supporting the claim, it was very hard for the Supreme Court to come up with a workable standard to say, well, these facts, will be enough and these facts won't. I mean, you'd hear every case up here at the Court of Appeals. If that, so I think they threw up their hands and said, as long as you've got some facts, we'll let that one go. Deer Valley takes the very kind of literalist, call it harsh if you want to, but, the law is the law approach on the amount requirement. And as I said, it's like filing your notice of appeal within 30 days. You know, if you don't do it, too bad. That's something that lawyers should be able to do. And that's what Deer Valley says. The only other thing I would like to comment on, and it wasn't brought up in the reply brief, but my client was interested in the effect of the bankruptcy court ruling. While this was in the bankruptcy court, Judge Baum said, oh, I think the notice of claim is not a problem here. I just wanted to, I think the fact that there's a published case that says the de novo standard of review makes that a moot point, and you are reviewing this de novo. I agree with that. So I think that there's the bankruptcy court ruling is of no consequence here.
Wouldn't it be relevant in the sense that the trial court abused its discretion in granting the motion?
Well,
I mean, it's not totally irrelevant. It's not just our review. It's whether the trial court should have taken a second look at the motion after the bankruptcy judge. Right?
You're right, Judge Gould. Analytically, there is a second moving part there, but the burden of proving abuse of discretion in that case would be on the appellant, which I guess my point is they already get de novo on the underlying issue. So in a way, I'm offering to excuse them from the need to show an abuse of discretion in second guessing that. So that's why I think it doesn't really matter.
I understand.
So I'm ready, willing, and able to answer questions. Otherwise, I shall sit down.
Thank you.
Thank you.
Counsel.
Thank you very much. And I'll be brief in my reply because I think a lot of the issues have been, the most pertinent issues have been talked about ad nauseum. But I think that when you look at the purpose of the notice of claim statute, the notice of claim that was served on the city fulfilled that requirement. It set forth an amount that a minor would take. It set forth the nature of the allegations, the basis for the claim, an unjust enrichment claim. It also contained, it seems now mistakenly so, it's one of the instances where you say, well, you gave us too much information. Because it got all the backup documentation. It got all the documentation showing that, they're obviously in default. Now we're looking for you to get paid because we filed this mechanics lien. We're substantially complete. This is what's owed on this date. And based upon that analysis, when you look at, and admittedly so, there have been different numbers bantered about throughout the.
Can I ask you a question,
Yes,
Counsel?
sir.
Why is the number in the note 1.6 million and the number in the lien 1.825? They're right around the same time period.
And that's part of the reason why you look at the completion date and what the actual amount is owed at the time. At the time that the note was entered, the amount that was owed was the 1.6. But then when you look at retention and what's owed on retention coming out, then at that point the number is going to be a final number, and that's why I use the date of completion as the final number of what's owed. So you can see it because normally when you have holdback retention is 10, sometimes 5%. So part of that money would be necessarily included in the final amount that's owed upon completion. And completion is when that money is owed, is when the retention is owed. And so that's why you do have a date certain when that amount is a liquidated sum, and it's upon substantial completion is when the retention amount is also due to the contractor, and so that's when you have the certain amount.
I have one last question, and that is, in the notice of claim, on page 2, it says, as reflected in the documentation included within Exhibit 2, the city is indebted to minor for $1.825 million plus additional accrued interest. I'm assuming Exhibit 2 was all the other documentation. I mean, all the things that were attached, not just the notice of claim, not just the notice of lien.
Yeah, I believe Exhibit 1 under the notice of claim was the contract, and Notice 2 was all the backup documentations with the pay applications, the letters saying that this was approved work, and the lien. That's correct, Your Honor. Well, my time is up, so I thank you very much for your time.
Thank you, counsel. I thank both counsel for their arguments. You helped to answer some of our questions. We will take this matter under advisement. We will issue a written decision in due course. And with that, we stand adjourned.